everyone. Our second speaker tonight is Roger Roots, who some of you know. In reading about him for this event and before, for a couple of other events we've attended together, I realized he's one of those people who, when you look at all they do and accomplished, you feel kind of lame. Roger is a nationally recognized attorney, a constitutional scholar, a civil liberties activist, often a libertarian candidate in Montana. Do you have anything to announce in that regard this year, Roger?
Not yet.
A writer, a FIJA board member, and all-around advocate. This is from his website, and I love these words. For the politically estranged and downtrodden. He recently worked on 2 cases that have received national attention, and during those cases, conscientious acquittal has played a major role. The Kleinman case in California and the Bundy case in Nevada. Please join me in welcoming Roger Roots.
Thank you so much, Cindy. Kirsten Tynan was up here a few minutes ago. She talked about the Keith Woods case in Michigan. FIJA has sort of gone on board with a couple of cases recently where we are supporting different court proceedings as friends of the court, where FIJA will file briefs as a friend of the court in support of a particular person. FIJA did file a brief in Keith Woods' most recent appeal in Michigan, and FIJA has also filed amicus briefs, friend of the court, that's called amicus curiae or amicus curiae brief, in the U.S. Ninth Circuit Court of Appeals in behalf of this gentleman, Mr. Noah Kleinman. Now, I wrote the brief in the Ninth Circuit. Who is Noah Kleinman? He's a guy in Los Angeles. He's currently doing a 17-and-a-half-year federal prison sentence. So as we go to bed tonight and we lay our heads on our pillows, we should all think about this gentleman here, Noah Kleinman, who is sleeping tonight in federal prison for essentially operating a medical marijuana business in Los Angeles. 17-and-a-half years. The Noah Kleinman case involved a lot of different issues. It involved the question of California state law versus federal law. Some of you probably know that the California voters resoundingly, a decade ago, voted to eliminate marijuana as a crime, marijuana sales as a crime. They voted basically overwhelmingly to allow for medical marijuana to be completely legal in the state of California. That, of course, conflicts with federal law, as we know. Federal law continues to state that marijuana trafficking for any reason, including medical, is a serious federal felony, and Mr. Kleinman was prosecuted to the fullest extent of the law, and he was subjected to a trial in the U.S. District of Southern California in a federal court. Go ahead and hit the next button if you would, Kirsten. The judge in that trial for Mr. Kleinman, this is back in 2014, gave this instruction to the jury, quote, "You cannot substitute your sense of justice, whatever that means, for your duty to follow the law, whether you agree with it or not. It is not for you to determine whether the law is just or whether the law is unjust. That cannot be your task. There is no such thing as valid jury nullification. You would violate your oath and the law if you willfully brought a verdict contrary to the law given to you in this case." Now, that was just one of the jury instructions that the judge gave to the jury. Now, there were a lot of other things that happened in the trial. Essentially, there had been jury education activists out on the street with flyers, with signs, and the prosecutors didn't like that. You know, some of us are familiar with big cases where activists are out on the sidewalk holding up signs supporting jury nullification or handing out jury rights literature of one kind or another. Prosecutors didn't like that. They got word to the judge. The judge didn't like that. And so he actually had several sessions where he would call in the jurors and ask them if they'd received any of this literature that was being handed out on the sidewalk, or if they'd seen any of the signs. By the way, almost none of the jurors actually saw any of the jury nullification signs or read any of the literature. This is what's sort of interesting about, these big federal trials. All of us are familiar with the Bundy trials. I've been working on the Bundy trials both in Oregon and in Nevada. You frequently see activists holding up signs, jury nullification, Google jury nullification and things. In fact, I've been in Nevada where I heard a crowd actually chanting as they were marching around the courthouse, "What do we want? Jury nullification." And I thought to myself, keep in mind, jury nullification means that you believe the government has proven its case. All right? And so I would sort of shake my head. I would say, do we really want jury nullification? Or do we want the jury to understand that the government has proven its case? Anyways, I never actually, voiced my opinion, but, remember that when you're asking for jury nullification, you are by definition admitting that you think the government proved its case beyond a reasonable doubt. Now, in this case, the Kleinman case, here's what sets this apart from most jury trials. By the way, these kinds of instructions you will see a lot, especially in federal court, where the judge will falsely tell the jury at the end of the trial, you are required to convict if you believe the government proved its case beyond a reasonable doubt. I've been in courtrooms where the federal judge will tell the jury at the end of the trial, jurors, if you believe the government proved its case beyond a reasonable doubt, you must find the defendant guilty. And it's not true. It's a lie. And frequently, they even emphasize one word, and that is the word must. And it's despicable. And as Kirsten laid out the history of jury rights in American history, it's just completely not true. And it's just false information. And I would say that it is jury tampering by the judge in these modern trials. So, Kirsten Tynan and I forget exactly how she became aware of this case. I think she was at a drug policy meeting. She heard about the Kleinman case and informed me about it. And she said, "Are you aware of this case?" I was not at that time. But we discussed it and looked into it. And FIJA decided to file a friend of the court brief to the U.S. Ninth Circuit Court of Appeals in San Francisco to support Mr. Kleinman in his attempt to overturn his conviction. Go ahead and click on the next one. The U.S. Ninth Circuit Court of Appeals, of course, is the largest of all the circuit courts of appeals in the United States. It covers all the federal courts in California, Nevada, Washington, Oregon, Montana, Idaho, Alaska, Hawaii. Generally, when you file an appeal of a conviction, you get a 3-judge panel. I believe there's like 29 total judges, but you get a 3-judge panel that's supposed to be randomly drawn. And Mr. Kleinman actually drew a pretty good panel of very solid judges. I'm not sure they were the best judges for him. They're very conservative. And let me just go. There was David Ebel, actually, who was a visiting judge from the 10th Circuit. And by the way, it's frequently, a lot of people don't know this, it's inside baseball, but lately in the last decade or so, it's been frequently, I guess it's increasing that a lot of these panels will include one member from either a U.S. district court somewhere, a lower judge, or from another circuit somewhere. What happens is all these judges get together at these fancy, schmancy, luxurious resorts every year. They have these conventions with each other. They become great friends, and they all want a guy from another court to come and sit by invitation on their 3-judge panel. So we had David Ebel, who was a senior judge from the 10th Circuit, Myron Smith out of actually Pendleton, Oregon, and Randy Smith from, I believe, Pocatello, Idaho. What's interesting is that, the Ninth Circuit is widely known to be liberal. This is an extremely conservative panel. I believe Myron Smith and extremely conservative panel, and very good judges, and I would say very respectable judges for most instances. Perhaps not in this kind of case, but go ahead and click the next slide. Anyway, they came down with an opinion. This is the U.S. Ninth Circuit in the Kleinman case. And again, I wrote a brief supporting FIJA to support Mr. Kleinman as a friend of the court. And the Ninth Circuit basically said jury nullification occurs when a jury acquits a defendant, even though the government proved beyond a reasonable doubt guilt. By the way, I'd actually say in my opinion, it's a little bit broader than that. It can also be, it can occur where a jury finds a lower degree of guilt when a higher degree of guilt would be more applicable under the facts. An example would be where a jury finds manslaughter instead of first-degree murder. I would say that's also a type of jury nullification. That actually happens a lot. By the way, it's very difficult to determine when that happens. We can all speculate about whether a given verdict was or was not jury nullification. It's very difficult. Or what Kirsten calls conscientious acquittal. It's very difficult to determine if something was or was not jury nullification. The Ninth Circuit panel went on to say, it is well established that jurors have the power to nullify, and this power is protected by freedom of recrimination or sanction after an acquittal. In other words, the jurors can never be punished. However, juries do not have the right to nullify. So the Ninth Circuit panel said juries have the power to nullify, but they don't have the right to nullify. And courts have no corresponding duty to ensure that juries are able to exercise this power, such as by giving jury instructions, informing the jury of their power. Okay, so this is sort of the standard in modern federal law, probably, which prevails in most of the circuits. This idea that, yeah, it's true, juries have the power to nullify. They have the power to acquit, conscientiously. They have the power to declare anyone not guilty for any reason, but they don't have the right to do so. And a lot of the modern judges almost seem like will almost write opinions suggesting that the jurors are doing something wrong if they nullify or conscientiously acquit. Go ahead to the next slide. Go on. Here again was that jury instruction that was given by the trial judge in Los Angeles. Click the next one. You see, why don't we juxtapose, go back and forth a little bit. Basically, you want to go back and forth. The Ninth Circuit agreed with FIJA. We actually won. FIJA actually was victorious partially in this opinion, where the Ninth Circuit agreed with us that the trial judge committed some errors, okay? They agreed with us that the last two lines were unconstitutional and illegal. However, the Ninth Circuit panel thought that the first three sentences were utterly proper and that there was no problem with that. Unfortunately, they upheld, even though they agreed that we had proven our point and that this was an illegal jury instruction, they upheld Mr. Kleinman's conviction and sentence. So he remains in prison, even though we proved and showed that that jury instruction was unlawful and improper. They basically said it's true that those last two sentences are false, but they said that the first two sentences are, that there's no problem with them. Now, I actually think that there's a big problem with the first three sentences as well. This idea that you cannot substitute your sense of justice, whatever that means. By the way, that is the very purpose of trial by jury. The absolute very purpose of trial by jury is for the jury to apply its sense of justice to the case. And yet they are falsely told, by the way, they're falsely told this many places, not just in this case, that you cannot consider your conscience. You have to follow the law as the judge gives it to you, jurors. So, FIJA agreed that we would support Mr. Kleinman's attorneys in further appeals, perhaps to the Supreme Court, but first of all to another stage where you appeal to other judges on the Ninth Circuit. Go ahead and click the next slide. before you go from the Ninth Circuit to the U.S. Supreme Court, you can do what is called a petition for rehearing. And you can do a petition for rehearing en banc, meaning by the entire bank of the Ninth Circuit. Now, there's 29 total judges on the Ninth Circuit, but you can ask for 11 judges to basically outvote the 3 that just voted against you. It's called a petition for rehearing en banc. And Noah Kleinman's attorneys petitioned for rehearing en banc, and FIJA filed a brief supporting Noah Kleinman's attorneys. It all turns on these terms: harmless error, reversible error, structural error, and plain error. We had proven that that jury instruction was error. It was false. It was illegal. That jury instruction was an illegal jury instruction. However, the Ninth Circuit said it was harmless error. Kleinman would have been convicted anyway, essentially. Now, here's what's important about the idea of harmless error. This is sort of a new doctrine in the law. I mean, it's sort of weaved its way through case law for hundreds of years. But in 1967, the U.S. Supreme Court decided a case called, I believe, Chapman versus California. And Chapman versus California, 1967, just 50 years ago. I'm literally the year of my birth, okay? 50 years ago. So it's a fairly new doctrine, the idea that a court of appeals can agree with you that you proved that the trial below was filled with errors, but it was harmless error. And here's what allows this. This is actually contempt for jury. This is actually a manifestation of contempt for the jury when you really think about it, because the court of appeals pretends that it can read the mind of the jury, and the court of appeals pretends that, well, we'll just replay the jury trial in our minds, and let's pretend that that problem was fixed, and even if that problem was fixed, the jury still would have convicted, therefore it was harmless error. And that doctrine now is, you see it all through federal court criminal case law, all over the place, harmless error. So a guy can win his appeal, and we did, but still sit in prison under the doctrine of harmless error. What we always try to show as appellate lawyers is reversible error, meaning an error that is not only just, a trivial thing, but an absolute major error in the trial which required reversal of the conviction. We argued on our rehearing brief that the jury instructions in the Kleinman trial were structural error, an error of such structural foundational problem that the entire trial was a farce, and it by definition had to be reversed. His conviction had to be reversed, and he had to get a new trial. I throw in the term plain error because it's also another term that comes. There is such thing as plain error, which means that even if the lawyer fails to object, a lawyer can still later on appeal and say, you know what, that was such a huge error, even though I didn't object, it's so obvious that it requires reversal. But in any case, FIJA argued that the jury instructions in the Kleinman trial constituted structural error. It really needed to be reversed. Mr. Kleinman needs to be released and have a new trial. Go ahead. Now, here's what happens. Here's what ultimately happened. We did not get our rehearing en banc. We got the same 3-judge panel who decided, you're right, you proved your point, our original opinion was a little bit wrong. Therefore, we will rehear the case, but we will just hear it ourselves, our 3 of us. And they did give it up to a vote, I guess, for the other 10, and the other 10 voted down. And so they ended up with a rehearing and a new court opinion that replaced the other one. This actually happens occasionally. So the new Kleinman case, there's been 2 Kleinman opinions of the Ninth Circuit. The new one replaced the old one. And the new one says, in most cases involving improper jury instruction, the Supreme Court has affirmed the appropriateness of harmless error review. So basically they just said, a bad jury instruction is not automatically something that calls for reversal, that in fact it can be subject to harmless error. And therefore they, again, a second time, upheld Noah Kleinman's conviction, and he is still in prison right now as I stand here. Structural error. One thing that we were trying to show is that jury instruction was the equivalent of like a wrong instruction on the idea of reasonable doubt. Reasonable doubt is something that is so rock solid that if a judge gives a bad instruction on reasonable doubt, it's automatic reversible error and it's structural error. And I was trying to argue that the jury instructions in this case were that level of impropriety. Nonetheless, the conviction has been upheld. Go ahead and click the next one. This is the Ninth Circuit. As we previously stated, there is no constitutional right to jury nullification, and it is not a constitutional error to give a firm instruction or admonition in an attempt to forestall or prevent nullification. So that's the new Kleinman opinion. Now, this, go ahead and click the next one. Here you see these, this is the brand new opinion. This is, again, David Ebel and the two Smiths, the two Smith judges on the Ninth Circuit. And from this point on, there is only one more place to go, and that is the U.S. Supreme Court. And by the way, just yesterday morning, I was on the phone with Kleinman's attorneys in California, and they are planning on seeking a certiorari to the U.S. Supreme Court. They're going to be filing a petition later on this spring, and FIJA, I believe, will be supporting that with a brief. Probably not me. Probably my brother Alex will take over because he's admitted to bar of the U.S. Supreme Court, and I'm not. But in any case, FIJA will be supporting Mr. Kleinman in his petition for cert to the U.S. Supreme Court. We hope that we can overturn his conviction ultimately. Go ahead and click the next one. Now we totally changed subjects. I've spent the last, now we're going to the Bundy cases. The power of the jury has never been shown better than in these cases. Let me just tell you, the juries have been the salvation of these trials. And I have spent the last year and a half working as an attorney and a paralegal and a legal researcher for the Bundy defense teams, especially Ryan Bundy and Cliven Bundy, beginning in Oregon and later on in Nevada. Let me just tell you, the right to jury trial has never been shown, has never shined, in my opinion, like it has in these cases. By the way, for the record, I want to recognize someone in the audience today, if he doesn't mind, and that is one of the defendants who was on trial there in Oregon, who is here today. Go ahead if you want to. Okay? Mr. Redoubt came all the way from completely not guilty by the jury in Portland, and he was one of the defendants on trial in that big, they call it the trial of the century that occurred in October 2016. I actually was sitting in the trial next to Ryan Bundy as his volunteer paralegal. Ryan Bundy was representing himself, as was Mettenbach, by the way. Great job.
Yes, yes.
And
Schindler helped quite a bit.
well, Schindler was his hybrid. Matthew Schindler was his standby counsel, and he did a fantastic job as well. That was an absolute stupendous trial. The government spent the entire trial showing these scary scenes, painting this dark picture of this occupation of these armed militiamen who took over this bird refuge and basically occupied it with weapons. And they had witness after witness about how just dark and scary it was. Then came time for, and by the way, they were lying, they were cheating, they were covering up evidence, they were preventing us from showing and cross-examining properly. Here's an example of this image was shown to the jury probably 3 or 4 or 5 times. This gentleman here, I don't know, do you know who that is? How do you know?
He has the same name as the guy who runs the Oath Keepers.
Well,
Stuart Rhodes. Last name was Rhodes.
Well, in any case, they kept showing this guy and some other guys with all of these weapons wandering around. Looks like rings of ammunition everywhere, body armor, the whole bit. They kept showing this to the jury. And these guys weren't even the occupiers. These guys were outside. These guys were out on the roads. They weren't even part of the occupation, or they weren't even part of the defendants that were on trial. These guys actually came in as sort of these buffer guys, where their goal was to keep safety and protect on the outside, on the roads. These guys weren't even on the inside, and yet the prosecutors kept showing images of all these heavily armed guys who were not even part of the occupation. Go ahead and hit the next. I want to point out that it is not uncommon in American history for demonstrators and protesters to take over and occupy public spaces with weapons. It's actually not that uncommon. It's happened many times. Kirsten pointed out that in the old slave days, where armed people would rush the jails, break open the jails, and free slaves with weapons. And, at political protest, demonstration, First Amendment protected stuff to some extent, not completely perhaps. But the point is, it is not unusual in American history for armed demonstrators to, engage in protests and demonstrations.
Sherry says the bearded guy is with PPN,
Okay.
non-oath keepers.
Right, PPN. What's that?
Pacific Patriot Network.
The guys with Pacific Patriot Network wasn't even with the group that was occupying the Bird Refuge. These are the Black Panthers in I believe 67 or so. They actually took over the California State Capitol with, semi-automatic Springfield weapons, and actually chased out the California State Legislature, 1967. I remember that. and again, it's not that unusual. If you look at American history, you can find things like this have occurred occasionally. And by the way, the longest sentence, these guys were prosecuted for a variety of offenses. The longest sentence served was 1 year in jail. And it's just important. It puts everything in perspective, because there was an element of the federal government that thought that the guys like Ken Menbach here should be looking at life in prison for taking over this wildlife refuge. Go ahead and click on the next one. That's another scene from the California State Legislature. Click on the next one. Anyway, before I move on to Bunkerville, Nevada, I just want to say the Oregon verdict to this day, it was probably one of the most earth-shaking verdicts when we got those acquittals in Portland, Oregon. The public that had been reading the newspapers couldn't even believe, they were so shocked. Anyone who had been outside the courthouse was so shocked by the verdict because they hadn't seen the trial like we had seen the trial. And let me just tell you, that dark scene that was painted and the violence and scariness, we put on witnesses that talked about how happy and jovial everybody was. What a nice group of people it was. Constitutional classes were being taught. The government's video that the government was constantly showing to the jury of these militia guys during the occupation, shooting at targets and things, were shown to have been an FBI undercover informant actually leading this target practice at the refuge. All right, so the jury came down with not guilty verdicts, which had to have shocked all the readers of the Oregonian and all the newspapers in Oregon. But they breathed life. They breathed a lot of hope into the people down in Nevada. There was 26 total defendants who were charged in Oregon, and there were 19 defendants charged in Nevada. Now, they were related cases in some ways because they involved the Bundys. By the way, wonderful family. I've come to know many of them. Wonderful group of people. In 2014, there was a big, you might say, just a conflict down in Nevada where the Bureau of Land Management was trying to round up a bunch of cattle that belonged to Clive and Bundy, cattle ranch in Nevada. And they were under I guess, the guise of executing court orders. The BLM arrived in the Bunkerville, Nevada area with hundreds of heavily armed agents, tanks, jeeps, helicopters, aircraft, undercover informants, surveillance operations of all kinds, just to round up cattle. They rounded up a bunch of cattle. They were yelling and shouting constantly at the local population. They beat up people. They threw women on the ground. They arrested people for taking pictures of Bureau of Land Management snipers. And finally, there was such an uproar that hundreds of Americans responded to and came to Nevada. Several of them brought weapons. And here's three of the defendants. This is Eric Parker. That's Scott Drexler and Steve Stewart. They were all defendants in the first Bundy trial in Nevada. And by the way, I worked both on the Ryan Bundy team and on the Cliven Bundy team in Nevada. Because we got those acquittals in Oregon, a lot of the guys in Nevada stuck to their guns, no pun intended, and refused to plead guilty. And they were all looking at life in prison, by the way, because they were charged in this 16-count indictment with all of these extremely serious felonies, such as using firearms in a crime of violence, which brings these mandatory minimum sentences. Congress wrote those laws, so it's a mandatory minimum 7-year sentence if convicted of the first count of using a firearm in a crime of violence. If convicted of a second count, it's 25 years to life. A third count, another 25 years to life, in addition to all the other sentences in the case. So all these guys were looking at potential life in prison. And the government probably spent, I estimate the federal government spent $250 million on these prosecutions. $250 million. By that I mean FBI agents by the thousands, scouring over people's emails, scouring over people's Facebook posts and comments. Massive investigations, undercover informants of all kinds. Again, we're living practically in East Germany right now. I mean, it's just pathetic. And I think the jurors in these cases don't like this. I can only praise the jurors. I can't praise them enough because ultimately, for those of you who know the most recent outcome of the big trial, the judge just dismissed the case. But lingering behind this is the fact that all parties now know that the government couldn't get the convictions because the jurors weren't going to give it to them. And because so few of them would plead guilty, the prosecutors and the judge had to separate the case into 3 different trial groups. So there were 19 total defendants. They were separated into 3 different groups. There were going to be 3 trials. The first trial was these guys, and the government called them the gunmen. They had pictures of them. Here you see Mr. Eric Parker, who's from Idaho, and he's positioned with a rifle, positioned in a crack on I-15 in Nevada. And of course, on the other side of that, it's a little bit blurry in the image, but there were Bureau of Land Management agents way down under there, and it was claimed that he was, aiming his weapon in that direction. By the way, whenever he's been interviewed about it, he has indicated that his intention was to save people's lives. In the event that the government had opened fire on those people down below, that he might have been able to get off some shots and maybe some warning shots, maybe get the government killers to duck behind some cover and might have saved a few lives. So he didn't even have a scope on the rifle. I mean, he probably could not have hit a target at that distance with any accuracy to speak of. Drexler at one point took a prone position, and it was photographed in that position, similar to Parker. Steve Stewart, I believe this is about the only image of him that in any way indicates he was holding a rifle in any way other than straight down. A lot of these guys did have rifles or pistols, but they were aimed straight at the ground. There is not a single image that exists of any of these defendants actually pointing any weapons in the direction of government agents. What happened is the first jury trial in February 2017 ended with a very, very mixed verdict. We were all on the edges of our seats. The jurors basically they hung on most of the counts. They did convict 2 gentlemen, Todd Engel and Greg Burleson, of some counts, but they hung on most of the counts. They acquitted these guys of conspiracy, by the way, but they hung on a lot of counts. So these guys were subjected to a second trial in the heat of summer, last summer, August 2017. And in that trial, I describe that trial as the most despicable trial that ever occurred in American history, because literally the jurors were treated to pictures like this. They were pictures that I guess the government thought would tend to show the guilt of the defendants, but the defendants were not allowed to show pictures showing their innocence or explaining the circumstances. Go ahead and click on the next one, if you would. This is sort of a bad image, but the jurors were not able to see the BLM in armed positions down below. The jurors were not allowed to hear the defendants describe how militarized and overbearing and over-aggressive the government agents were. Literally, they were stopped completely whenever the defendants would try to object to a government witness or would try to put on any evidence explaining the setting, the circumstances. They were stopped. The rules of evidence were deployed completely in the government's favor. And the jury came back. The most astounding thing I've ever seen in my life was, well, for one thing, Eric Parker took the stand in his own defense. And his attorney asked him, well, which direction were you looking? He said, up and to the right. Objection! Literally, the prosecutor objected to him saying he looked up and to the right, and said, well, that might, and went back to a sidebar outside the presence of all of us in the audience, and all of us in the jurors were not seeing this either. But the prosecutors were saying that when Parker said he looked up and to the right, he might have been suggesting that he was referring to BLM snipers that were up on the mesa, and that's a prohibited topic. The jury isn't supposed to know there were government snipers up on the upper mesas. I'm not kidding. I really saw it with my own eyes. It was the most despicable trial that ever occurred in American history. The defense lawyers on the last day, some of us were in the room. Mr. Bland was in the room. Several of us were there. I mean, the defense lawyers stood up and literally said, Your Honor, we're not even going to give closing arguments. Now, for those of us who are attorneys or who watch a lot of court cases, it's not unusual for a lawyer to not give a defense. In other words, not put on any evidence. Sometimes a smart defense lawyer will say, you know what, the government hasn't proven its case. We don't even have to prove a single thing. We're not going to put on a single witness. We're not going to put on a single fact. But they will still go and make an argument. They will make a closing argument to the jury. In this case, the defense lawyers didn't even put on closing arguments. And like I said, it was the most astounding thing. It was like, I've always said, it was a Hail Mary pass. And it was a cry for help to the jury. And the jury heard it. They caught the pass in the touchdown. And they declared Steve Stewart and Ricky Lovelane, a Montanan, by the way, completely not guilty, acquitted them of all charges. They acquitted Parker and Drexler of most of the charges, but hung on a small number of charges for Parker and Drexler. So they were actually at one point looking at a third potential trial. They ultimately ended up taking some misdemeanor plea deals, Parker and Drexler did. Anyway, that led to the big trial, which just started in, I guess, last October. The big trial was the so-called conspiracy leadership, according to the prosecutors. And that was Cliven Bundy, Ryan Bundy, Emmett Bundy, and Ryan Payne, another Montanan. By the way, there have been a lot of Montanans in these cases. Ryan Payne, Lovelane, Jake Ryan, who lives not too far from where we are right now, who's currently in jail for the Oregon occupation case for digging a trench, basically. He was convicted by a jury in the second Oregon trial of damaging the property of the United States more than $1,000. He's a local guy he lives not too far from where we are right now.
So they're Jason somebody?
What's that?
Patrick.
Yeah, Jake was from Anaconda.
Jason Patrick.
Brian Payne's from Anaconda. There've been a lot of Montanans in these cases. But in any case, the jury came back, acquitted Lane and sort of all counts and mostly acquitted Parker and Dressler. That sort of flowed into the big trial. And for those of you who've been following this, the judge in the big trial, starting in October, started to, I think, realize what I think everyone was realizing, including the prosecutors, which is that the jurors weren't convicting these guys like the prosecutors thought they would. And ultimately, the judge dismissed the case with prejudice, meaning they can't bring it up again. They dismissed the entire trial with Clyde and Ryan Cameron and Ryan Payne. And just in the past week, by the way, they also have dismissed with prejudice the third trial group involving Mel Bundy, Dave Bundy, Joseph O'Shaughnessy, and Jason Woods, just in the past week. So we have had great victories in these cases, and it's all because of the juries. It really is. The juries, I would say it's great news. It shows a lot of great things about the future of America, that this East Berlin, like, surveillance society that the government wants to impose on us, with undercover informants everywhere, surveillance of all things, I don't think the juries like it. And the juries have handed the government some major defeats in these cases. And with that, go ahead and click. I think that might be the last slide. With that, I will conclude and take any questions that anyone has.
Roger.
Who's paying for the defense for all of this?
The question was, who's paying for the defense? Well, almost all of it has been court appointed. Public defender, by the way, Ryan Payne's team ultimately, Ryan Payne was represented by the Federal Defender's Office of Nevada, and they ultimately filed the winning brief in the case, the motion to dismiss, which ultimately was the successful motion. I worked on a lot of research on the background of a lot of these motions for the Cliven team and the Ryan team, and I've lived on a shoestring in the last year and a half. I literally slept on a cot most of the time. I had some great, wonderful people who put a roof over my head and fed me quite a bit, and I survived on donations. And go ahead.
This is Roger's defense. He, I slept in the same cots with him. Out of all the attorneys there in Oregon and Nevada, he was the less paid attorney there. He volunteered his service, and we couldn't have done it without Roger.
I can only say it's one of the greatest experiences of my life. I've met a lot of wonderful people, and I've seen some of the biggest trials in the country. I frequently tell people I'm the only person who witnessed all four of the major Bundy trials. The only one I missed was the second Oregon trial, with the one with Jake Ryan. I missed that because it occurred at the same time as the first Nevada trial. But I saw, I was present either at the table or in the audience taking notes for the defense teams in all four of the Bundy trials.
You didn't complete your the part about Eric Parker's testimony. What happened to his testimony?
Oh, I forgot.
Yeah.
I started that story but didn't finish it. Eric Parker, after the prosecutors objected to him saying that he looked up and to the right, the judge came out and ordered the jury to strike what they had heard him say, and she ordered him off the witness stand. It was astounding. She literally ordered Eric Parker off the witness stand. Here he is on trial for his life, looking at potential life in prison. And the judge said that because he said the words, up and to the right, that he couldn't continue as a witness, and she ordered the jury to strike his testimony. I mean, it really happened. Like I said, it was the most despicable trial in American history, and the jury punished the prosecutors for it. Go ahead.
Just state, that I-15 bridge, my wife and I crossed that bridge many times. Where Eric was, it was over a quarter of a mile. Without a scope, he wasn't going to get anything at that intersection. Also, I knew several people from
Yeah, and by the way, I've interviewed a lot of witnesses who were down below in the wash in April 2014, who openly say that the militia guys saved their lives. Because if it hadn't been for armed Americans prepared, again, they weren't in place, they weren't aiming at anything, but if it hadn't been for large numbers of armed Americans, the government probably would have opened fire and killed a lot of innocent people.
Another state. I lived in Nevada for 19 years. So I see a lot of the ranchers taken. My wife and I had a lot of rallies for these people. We stood in front of the Reno Federal Court building several times for several ranchers that got their cattle taken away. I mean, completely taken away, stolen. But we have a friend that lives in Nye County. And at that time, Sheriff Moyes, I believe it was, our friend David Holdren and his wife Jackie had run Longhorn down in Nye County. The BLM were harassing him, saying that they're going to take his cows. David called the sheriff. The sheriff showed up with all his deputies. The BLM showed up armed. The sheriff asked the deputy through the BLM, "What are you going to do?" He said, "We came to take his cows because he's trespassing his cows on federal property." The sheriff says, "If you cross that gate, I'm going to arrest you for trespassing, and I'm going to arrest you for cattle rustling if you take any cows." The BLM said, "I have a SWAT team here." The sheriff said, "I have my deputies, my SWAT team as well." BLM got in their vehicles, they took off and never came back. David Holgram, I know, was down at the Bundy Ranch.
I've spoken to him on the phone.
David is a very good man, and I was actually, the day before I left Nevada, I happened to run into David on the highway, and we talked for about 10, 15 minutes. I said my farewells to him. That was it.
Okay, Dennis,
Yes.
are you supporting Brannigan for sheriff in FIJA County?
I'm not sure yet. I'm not sure who I haven't talked to any of the others.
There's a question. Another question.
This is a good man here.
There's a question from Andrea Parker here. She said to ask about how the 8 jurors that were released from the trial there, how they came and they talked and seeing at the judge's final decision there. They even one of them hugged Brian.
Oh,
Yeah.
listen, I can tell you on the last day when the judge dismissed the case, I literally was crying myself. Tears were flowing down my face. In the hallway, waiting to get into the audience of that final day's hearing, were 8 of the jurors. The jurors who were basically had been dismissed a couple weeks earlier and told to go home because it was a mistrial declared. The jurors came to watch the ultimate proceedings of the case, and they wanted to meet the defendants, Ryan Bundy. Some of them hugged Ryan Bundy, shook Ryan Bundy's hands, shook the hands of the defendants. So if the big trial had gone to a jury, more than likely it would have been a full acquittal. And I think everyone knew it, including the prosecutors.
I read that the prosecutor wants to re-prosecute or trying the judge to reverse her decision on the dismissal.
Yeah,
What's that all about?
just last week, the prosecution filed a 29-page motion for reconsideration, wanting the trial judge in Nevada to reverse herself and basically reverse the dismissal and allow for another trial to begin with the big group, including Cliven. My take on that is it's not likely to be granted, although I could be wrong. I could always be wrong. My take on that is that the prosecution has been sort of embarrassed by the case. Basically, they have been found to have been withholding exculpatory evidence from the defense, meaning evidence that tends to show the innocence of the defendants. Now, that's a big violation for prosecutors if you are caught with withholding of innocence from the defense teams. And the judge found these 8 instances, material instances, where the prosecution had failed to provide exculpatory evidence to the defense. By the way, there are probably a lot more than that. And so the prosecutors have been embarrassed. They've been disgraced. And they are looking for another opinion, probably trying to look for a reversal of that. I wouldn't be at all surprised if the prosecutors ultimately appeal to the Ninth Circuit, and who knows what might happen down the road.
Roger, having been there, I think that's just ludicrous. I mean, there's so many lies. You know, the Wooten email came out, but that's not all that was uncovered that they hid. There's so much more. And the people who testified, Shalakas and Rugwell and that other gal, all of their lies have all been uncovered and will be revealed. If they retry, it's just going to be pitiful.
The more
It's
information that
ridiculous.
comes out, the more it becomes clear that the prosecutors were manipulating, they were lying all through these cases. For example, on the indictment itself is about 60 pages, and it contains an accusation against the Bundys that the Bundys had lied in order to get militia people to come to their aid by telling people that there were BLM snipers around the ranch. So this is an accusation on the indictment. The federal prosecutors put this accusation on the indictment, saying that Cliven Bundy and the other Bundys had lied about BLM snipers surrounding the house and the ranch. And as we litigated this case all the way through, they kept trying to stop all inquiries into the existence or non-existence of BLM snipers. So on the one hand, they make the accusation that the defendants were lying, but on the other hand, they're simultaneously stopping the defense from uncovering evidence of BLM snipers. And when it became clear, by the way, that there were BLM snipers, they actually had sniper units positioned on all the hillsides. And by the way, there were documents that show that the prosecutors and the high-level FBI case agents actually apparently seem to have told witnesses to change their stories. For example, a BLM witness wrote out a report saying, I was a spotter for a sniper. A BLM agent was a spotter for a BLM sniper. That was in his original report. Then he meets with the FBI and the prosecution team. Then he changes his report and said, oh, I never said that. So there had been efforts by the prosecution team and the FBI to get the witnesses to change their stories all through the case.
Isn't it true that the BLM agents were actually pulling triggers before this all went down? And if that's true, how many cows were killed?
Well, by the way, another thing with regard to the jury, the defendants were not allowed to tell the jury that the BLM was killing any cattle. They were not allowed to even mention it. It's not even clear how many cattle were killed. Cliven Bundy thinks there were at least 40, maybe 50 cattle that were killed. It's impossible to say because they buried some of them.
Just try to pull.
Yeah, a lot of breeding bulls. Big bulls were killed, shot.
These cows, some of them were dug up.
Some were dug up. That's right.